Most family law matters are resolved by agreement between the spouses, and most claims against family law lawyers relate to advising on or preparing written settlement agreements. We at LIF have found that the most common claims relate to a failure to adequately address some aspects of those agreements, which I will review today. First, disclosure. Failing to have your client provide full disclosure or obtain full disclosure of all assets, liabilities, and debts can lead to a later claim of damages arising from negligence. Here's an example from our claim files where this was overlooked. A lawyer acting for a husband approved a separation agreement that took into account several false debts claimed by his wife. These included a credit card debt that was no longer valid given the expiry of the limitation period, and an alleged debt owing to an insurance company that was not in fact owing. The lawyer failed to validate and confirm these debts, resulting in LIF having to reimburse the husband over $50,000. Of course, an agreement can be set aside if a party fails to disclose significant assets or debts or other information relevant to the negotiation of the agreement. However, it's prudent to include a term in any agreement stating that each party has provided full disclosure of all assets and liabilities, and the agreement may otherwise be set aside. It's also important to make it clear to your client that they must fully disclose all relevant information to their spouse in negotiating and entering into an agreement. Second, independent legal advice or ILA. Failing to recommend that a client or other party seek independent advice and mistakes in providing adequate independent legal advice can lead to a claim against you. If your client's spouse has not retained a lawyer, it's important that they obtain ILA before signing the agreement. Otherwise, there's a risk that they may be able to set aside the agreement on the basis that they didn't understand the nature or consequences of it. Just recently, we received a report from a lawyer who was asked to provide ILA to a wife. He spent 20 minutes reviewing the separation agreement with the wife. The lawyer told us he witnessed her signature when he was satisfied that she understood it. But his client later applied to overturn the agreement on the basis that it was significantly unfair and the ILA was inadequate. When providing ILA, you should go further than just ensuring your client understands the agreement. Make inquiries so you're fully apprised of the circumstances surrounding the agreement. Advise your client of their legal rights and obligations under the agreement, and offer your opinion on whether it's appropriate for your client to sign it. We have an ILA checklist on our website and can't recommend enough that you use it to ensure you've covered your bases. On a related note, consider whether any party to the agreement is under or can assert they are under duress. An agreement will be set aside if one spouse takes improper advantage of the other spouse's vulnerability, including ignorance, need, or distress. You should make inquiries to ensure your client is not under any form of duress, including assessing whether family violence may be present, which is a requirement under the Family Law Act. A fourth commonly overlooked item is tax. Often, tax consequences are involved in property division, pensions, spousal support, childcare expenses, and corporate matters. Make sure your client gets the advice they need from a tax specialist who can fully advise them on the tax implications of matrimonial agreements. Finally, we see many reports resulting from clerical errors and for ambiguous or unclear wording in agreements. In one of our files, a lawyer accidentally reversed what was to be provided to the husband and wife in one paragraph of their separation agreement. Luckily, the other party consented to a correction of the agreement. In other cases, we've not been so lucky, and these simple errors can unfortunately have costly results. An extra review would have prevented many of these types of errors. Keep these tips in mind the next time you're dealing with a separation or marriage agreement so that you and your client can avoid these common pitfalls.